will is a document that speaks to how a person who has made the will, who is called a testator, would like that person's estate, which means whatever they die leaving, dealt with upon their death. It is what gives the executor the legal authority to act upon the testator's wishes. A lot of people are of the view that they don't need to make a will because they have nothing. However, that's not a good plan, especially if you have children, because you know you can go out on the road and you get hit down, as happens. There's a motor vehicle accident and you die. If you die leaving a will, then somebody is immediately able to step in to apply for probate and to be able to bring a suit on behalf of the estate for your wrongful death. If there is no will, then you have to go through the process of bringing the matter to the attention of an Administrator General and getting the Administrator General's advice and instructions as to how to proceed. And it becomes really complicated if there are children. When a person dies, they die either having made a will, which is referred to as dying testate, or not having made a will, which is referred to as dying intestate. Now, when a person dies intestate, that is, not having made a will, there are different rules that come into play about how and who has the authority to become the administrator of that person's estate. And if there is no will, then the law steps in and says who will have the authority to do that. It is of particular importance who will have the legal authority to handle the estate, especially when there are children involved, because when there are children involved, the Administrator General of Jamaica is the person who has the legal authority to administer that estate. When there are no underage children involved, the Administrator General, if an application is made to the Administrator General, might consider giving authority to an adult beneficiary under that estate to apply to become the administrator, with, of course, the consent of all the other persons who would benefit. First of all, I always advise persons to make a list of all of the assets that they have. That could be property, real property. It could be furniture in their house. It could be the house. It could be land. It could be stocks and shares. It could be interest in companies. It could be money in the bank, whether it is in fixed deposit, whether it is in savings account, whether it is in a checking account. It could be life insurance policies. It could be jewelry. They make a list of what they have. And you know, what I find in my experience is that people think they have nothing, and then they start to, it could be, for example, artwork on the walls. You know, they think they have nothing, but then as they begin to say, some people even will their clothes, you know. So you make a list, but probably the most important thing that you have to consider is who are going to be your executors, because your executors will have the responsibility of seeing to it that your wishes are carried out, and carried out in a timely manner. You don't want to have young children and your executors take forever to have the will probated, and the young children grow up not being able to get access to the money that might be there to look after their welfare. So you really have to have persons named as your executor who are willing to do the job and who you trust to look after your family or whoever it is that you're leaving as the beneficiaries. The person who makes the will is called a testator. So a person, the will starts off by saying I, the name of the person. So the name of the person, their address and their occupation, declaring that this is their last will and testament, and then indicating that this will cancel any that has been made before. Then the testator appoints the administrator, the executors, the persons who will have the legal right to wind up the estate. We suggest that you name at least 2 executors, because if one dies, there will be somebody else who will be able to, another executor. So you need the address, occupation of the executors, and it's good to tell them that they're being named and ask their permission that they're being named as the executors. And then in the will, you instruct the executors to pay funeral expenses if that is part of what they need to do, and you give them the authority to pay all the expenses that are required, and then to settle all outstanding debts. And then from what is left now, you give what is called the bequests or bequeaths, which is really the gifts, who it is you are giving what. As far as possible, you need to be, the person making the will need to be very clear in what their wishes are, so that the executor will know how to proceed once they are named by the court, which means once they have the probate in hand. So it is always good to indicate, you know, I give my jewelry to my big daughter, or for example, or I give the half share of my house which I got from my grandparents to my cousins. You know, you set it out, and if you can name the people, it is better. If you can identify the property specifically, so you can say my life insurance companies, my life insurance coverage with Sagicor, or my life insurance company coverage with whichever, Guardian Life or whatever, my cash in the bank, my stocks and shares, and you indicate who you want to get what. And then after you've done that, it's always good to have what is called a residual clause, which basically says anything I haven't set out specifically, I will give to whoever, you know, a named person or persons. And then the will has to be dated, and the testator signs the will in the presence of 2 witnesses. Well, first of all, the will has to be dated. It has to identify the person making the will very clearly. It really ought to have the executors named, and it has to be witnessed by 2 persons who are preferably not, well, not preferably, who are not beneficiaries to the will. Those are what you need to have. Sometimes the language, you know, when somebody tries to make the will themselves, they use language which is not clear, or which in the layman's point of view means one thing, but in law means something else. And so it is always the best thing to do to get a lawyer to draft your will for you. Well, the first do is get a lawyer. The main don't I would say is do not have the witness be somebody who is going to benefit under the will. Another do would be, if you are not setting out all of the property that you own, and you're in the will, and you are doing a general provision, like for example, if I'm making a will, I have 1 son, I would say I give all I possessed of to my son. Then that is very straight, because there's nobody else who I would be doing it to, would be leaving my property to. However, let us say my mother is still alive, my sisters are still alive, my brothers are still alive, and I want to give them something. Then I would have to then say I would like to give so and so to my mother, or I would like to give my jewelry to my niece, and I would say her name, or I would like to give my motor vehicle to my son, and I would like to give my, you know, you set it out. And then I might say everything else that I have not mentioned specifically will now go to my son. All the rest, residue and remainder, will go to my son. So it's important now, if you are not going to be setting out everything like that, that you at least have a listing elsewhere which would be available to your executors, because when your executor gets is to get probate, they will have to do a statement to say what constitutes the value of this estate, what are the items in the estate. So you have to have a list somewhere, which I would suggest is kept with the will, so that they will at least know what is the property that you have left. Once you become an adult, 18 years old, and let me tell you something, you can write a will every week. So that, you know, there are some people who feel if you write a will, you're going to die. I have been making a will since I was 25 years old. And ever so often, and this is also advice that I would give, is that if you have done a will 10 years ago, you need to go back and look at it and see whether anything in your life has changed, whether you want to make different provisions. Additionally, if you have made a will already and you get married, that will has been cancelled. So you need to make another one after the marriage. So the act of marriage invalidates a will that you have made already. So I suggest that everybody who's getting married, as soon as they get married, you make another will. You can make a will as often as you want. Your life changed. What I wrote in my will when I was 25 is certainly not what was in my will when I was 40, and it's certainly not what it is now that my son has grown up. For example, when he was a minor, I had to name persons who would be trustees and who would look after anything that he would have gotten during that time. So now that he's an adult, I don't need to name trustees again, so I changed the will and take out the trustees. I always tell people about the Bob Marley estate. He died without leaving a will. He had many children who all had a claim on the estate. And you know, if his widow was not the kind of person who she was and acknowledged those children and determined that she would make the appropriate provisions for them, it would have taken forever. As it was, I think that estate took over 15 years to be wound up. Jamaicans have this view, and I've said it already, that if you make a will, it means you are going to die. I would like to suggest that this is not a view that needs to be held. There are so many people who have made a will and have not yet died, and who have changed their will as their life changes. I would like to suggest that people really consider making a will, because it certainly makes your life, not your life, you would have been dead by then, makes the life of your beneficiaries much easier. It speaks to how you want your property to be shared, and it gives somebody authority to act as your legal representative.